And I think if I asked you to, trek all the way over to campus for a 20-minute discussion about a class that I teach, I don't know how many of you would have shown up. So, the fact that we're able to do this on Zoom, where if you have a device, if you have an internet connection, you're able to click in and we're able to meet and connect this way. I think that is one silver lining of this otherwise very difficult circumstance. But it is May 1st, the start of a new month. In Korea, actually, May is Family Month. It's Family and Community Month. It's a day filled with days that celebrate family and community. Children's Day, Parents' Day, Teachers' Day, and so I really hope that each of you and your families are happy, healthy, and well, and that soon, not in the not too distant future, we can all reconnect and regain and really cherish those relationships which we so miss now that we are unable to enjoy them in the ways that we had been able to in the past. So before I begin, actually, I wanted to start with a huge thanks. You'll see if you're in the gallery view, UCI Law Zoom is actually not her name. It's Rebecca Bergeron, who is our co-host and who has been, handling the registrations, the dissemination of the links. So without Rebecca, this would not have been possible. So I wanted to thank Rebecca and Marianne Soden, who you see in the gallery as well. She is the mastermind behind Faculty Fridays. It was actually not supposed to happen this way. We were going to get into a room, actually, a physical room. And, Josh and Omri and I were going to each, pitch the various things that we were doing in our teaching and research and programs here at UCI Law. But very quickly things changed, and Marianne was extremely innovative and nimble in jumping in and say, hey, let's move this online. And so thank you, Marianne, for orchestrating this. And I hope that you were able to join the two other sessions. One was led by Omri. He talked, I believe, about weaving in artificial intelligence into our graduate tax program, which has been really so successful in its early years, and together with the international LLM program that we have, we've just been able to build a robust program that really is symbiotic with our JD program as well. And Josh Blank, he started a UCI Law in New York initiative. And so I think that was the topic that he talked about a week or so ago. So I hope you were able to participate in those sessions as well. The topic that I'm going to be talking about is corporate law and practice in the intelligence age. As some of you may know, because I see former students here in this room as well, but I also see new names, so you may not know. I teach contracts and corporate governance and corporate law here at UCI. And when our visionary dean, Song Richardson, told us, or nudged us, I should say, more than I think a year ago, that each of us should start thinking about how to incorporate emerging technologies and their impact on the areas that we teach and write in. I thought, what a great idea, and actually how irresponsible it would be for me not to talk about, especially in the area of contracts and corporate law, corporate governance, securities regulation. I think it's hard to imagine any corner of any of those laws that is not going to be impacted, if it hasn't already, by some of the emerging technologies, some of which I'll be talking about today. So just as an example, if you think about contracts, what is contracts? Essentially, contracts are an exchange of promises, right? And when we think of a contract, if I ask you to close your eyes and imagine a contract, you might, think of white paper, black text, a wet signature at the end. But I'll be willing to place a bet that, not too far from now, we might look at paper contracts like we do today at like wax seal stamps, something that is like a really cool thing from the past that no one uses anymore, unless, it's for decorative or, a celebration, something just as a nice sort of addition, but really the substance of it, I think we will see, will move on to the digital space. And in particular, many of you are probably familiar with smart contracts. These are computer code or protocol-based contracts that are designed so that they automatically and digitally facilitate, verify, and enforce the performance of a contract. So now the legal enforceability of a contract does not ride on, right, the credibility of the parties coming to the table, the strength of your handshake, right, or the validity of the witnesses who observed you as you were signing the document. Rather, it's on the durability of your code. And so everything having to be pre-written into the program ensures efficiency and automation. But a lot of the topics that I spend much time on in my first year contracts class, like principles of interpretation or the materiality of the breach, right? To the extent that it's a small breach or an immaterial breach, we may be willing to forgive. To the extent there's changed circumstances, we might be able to incorporate a grace period. Principles of interpretation, the famous, what is a chicken case that those of you who have gone to law school might remember. It's one of those cases that you can't forget. Is it a young chicken, an old chicken, a big chicken, a small chicken? None of these will remain unanswered when we have to execute contracts by computer code, right? So ambiguity, fights about whose meaning prevails, all of those will disintegrate because the code will discipline us and force us to be clear at the outset about what our priors are. And so, it will really have a profound impact on the way we think about contracts and the way we draft them. And it will be important for lawyers and regulators to work with experts or themselves become experts so that they can draft, negotiate, revise, and enforce these agreements. Let me show you an example. I saw Pierre had called in as well, but if you see in the gallery view, Pierre, if you could just wave your hand. Yes, so that's my co-author, Pierre. He's a research fellow in the Korea Law Center, but before he joined us at the Korea Law Center, he was an engineer at Samsung for 10 years. And he and I came together to write a paper about how we can use smart contracts to incentivize retail shareholder participation in corporate voting. And I just wanted to share with you, this is the pseudo code that Pierre had written so that we could sort of show our readers what the execution of our idea would look like. Imagine if a shareholder, were given, quote unquote, the opportunity to read this contract. I don't know how helpful they would find it, right? A layperson. If we're already worried about people not paying attention to contracts because they are too long, or the font is too small, or they just want to get to the product and don't want to deal with these pesky clicks that they have to jump through to get there, we should be even more concerned. So I think, literacy, thinking about intersections between law and cryptography to create hybrid systems, sort of in the way we have with law and accounting, and law and patent law. I think that's a really important innovation that we should keep in mind as we think about the next generation of lawyering and contract drafting. And same thing for corporate law, as we transition from sort of the left-hand side image, that's your typical boardroom. And I especially love this image because of its diversity. But, you have human beings sitting around a table in a conference room that looks familiar with this, with the with their laptops, having a board meeting. What happens as we move from that left panel over to the right-hand side, where you see two worried folks and then one a static robot? This is not something that is imagined or hypothetical. You may have already read about Deep Knowledge Ventures, which is a Hong Kong-based venture capital firm that appointed an AI, an artificial intelligence tool, to its board, right? Its name is Vital. And it basically takes all the data about past and current investments that this company has made in the life sciences and makes projections and business decisions about which portfolio companies to invest in. Exactly what you would imagine a fund manager or a board member to oversee. And he does it, or it does it, I should say, quicker, without error, without biases, to the extent that it has been programmed in such a way. And so as I was reading the article that announced this radical appointment, the observer, mused, he said, what happens when the board goes out for happy hour? Should they bring Vital along, in the spirit of inclusion? But, as I was reading that, for me as a corporate law professor, my thought was, what happens when there is a breach of fiduciary duty? For instance, if there's a breach of the board's duty of care or duty of loyalty, should Vital be considered an independent board member? And when we think about the standard of review, how should we measure Vital's performance and inputs? Is it measured against a natural person? And ultimately, to the extent that we find Vital to be liable, who pays, right? Is it Vital's ultimate creator, right? Aging Analytics, which is the UK company that developed Vital and receives a fee in exchange for loaning it out as board members, as advisors, as consultants, right? So there are all these really interesting questions that arise at the intersection of corporate law and technology. But it's not only questions. Like I mentioned earlier, there's also new solutions that can be imagined to old problems. So as I mentioned, that paper that Pierre and I wrote, that phenomenon of shareholder apathy, according to the most recent data, less than 30% of retail shareholders voted in the past proxy season, compared to the 92% of institutions that voted. And so there is this gap in shareholder voting. And so, we were able to think of various blockchain-based smart contract solutions to make voting more attractive, more easy, and more reliable and more informed, in order to level that playing field between retail and institutional shareholders. So, I think technology, it can widens gaps, but it can also be used to bridge gaps as well. And I think most important, which I wanted to highlight, and I think this is a theme that underlines this class and the way I teach it as well, is that, we're not just defenseless. We're not just on the receiving end. It's not like that technology gets thrown at us and we have to sort of shield and emerge from it and try to survive. It's actually a two-way conversation. And I tell my students, all of these debates and ideas that lawyers and the legal profession has developed. For instance, take the century-long debate about corporate personhood. Should we treat corporations as people? Should they be viewed as persons through the eyes of the law for purposes of thinking about what rights they should have? Does a corporation have a right to free speech, a right to free association? It certainly has an obligation to pay taxes, right? Enter into contracts, and it should have the ability to own and sell real and intangible properties, right? But where do we draw that line? That's been a really long and deep and contentious question that we've been grappling with. And so those lessons can certainly be applied as we think about the next question, I think, that will dominate our thinking, which is, how should we treat machines, which are another type of artificial entity? should they be viewed as persons for select purposes through the eyes of the law? And I think that cannot be a blanket question. We have to really draw from the wisdom of of corporate personhood. And so environmental personhood is another area that we can draw from. And so these are all lessons that repeat themselves. And I think, what's important to emphasize is that it is a two-way conversation. And so let me get to the topic. So this was how, this course came about. We got the suggestion from our dean that, we should be thinking about how to incorporate these new topics. And I thought, why don't I design a class that's just solely about this? So, the name of the class was Corporate Law and Practice in the Intelligence Age. It was offered for the first time this spring semester. We just wrapped up last week, actually. And for those of you who are alums, you might remember your seminars being, 5 or at most 10 people in the room. I will tell you, the response from the students was overwhelming. This is the largest seminar I've ever taught. It was 30 students. It was oversubscribed. We had a wait list. I hope that this is a class that I can teach every semester. And really the vision that I have for this class is that it is taught at every single law school and maybe even some of the business schools, right? Because I think it's such an important topic that, forces us to think outside of the box and also prepare for what's ahead and forge new connections, cross disciplines, and think of new ideas and, imagine new solutions to new and old problems. So how did I pitch this class? So I told the students, there's 2 learning objectives. The first thing we'll do is to understand the forces that are driving the digital transformation. And then second, we will be discussing the specific rules and processes and practices to prepare for future opportunities as well as upheavals in corporate law and practice. And in the opening class, the question that I asked was, what do you think is one technology, product, or service with the greatest potential to disrupt the legal profession in the next 5 years? And here were some of the ideas that students came to the table with. One of the students, he was going to be headed to Wilson Sonsini in the summer. And so he shared with us 650, which, as many of you may know, is the technology subsidiary of Wilson Sonsini. And they've been sort of developing privacy suites and other automated legal tools to help their clients comply with new privacy laws, notably the California Consumer Privacy Act and the EU's GDPR, and most recently, how companies can respond to various claims that are arising as a result of COVID-19. And so, automation of lawyering, but with the supervision and design input by lawyers, right? How does that interaction will really change the way we work and the way we liaise with our clients, right? And how we add value. Really interesting, right? This was in January when we started our spring semester. Zoom, who knew we would all become Zoom experts? But at the time, a few students had already been familiar with Zoom because of their circumstances. One of our students, they had they were doing remote learning starting from the previous semester, and so there was already this familiarity with Zoom, and we were thinking about what could that mean for the legal profession, right? If lawyers could work from home and serve their clients from home or from wherever, right? That was, I think, the beauty of it. It could be from the home, it could be from the office, but it could be really from anywhere where there's an internet connection. What does that mean for work-life balance? I remember hearing stories about from partners when I was in law practice about, we couldn't get work done over the weekends unless you were sitting in front of the fax machine, right? Because that was the way people corresponded with one another. With the advent of email, it does mean that you can, leave your physical office because you can bring home work with you, bring work home with you. But the other side of that is that you can never leave work, right? So, I think we've had some really interesting conversations about that. Legal Nation is The tools, as some of you may know, we as a faculty received a demo, and I was fascinated. What we saw was that, work that would normally take a lawyer a day or two was done in the press of a button in 2 minutes. And so what does that mean about the future of work? We also talked about prediction and litigation analytics. This is a very crowded market, but Bloomberg most recently announced that it was also throwing its name into the ring. And, it's leveraging, it's a data company essentially, right? It's leveraging the data and information that it has on the millions of private and public companies that it's been tracking. And it uses that big data to make predictions about, depending on who represents what, and for which judge, what the outcomes might be. And so it's a very powerful tool that might offer new insights about how we can leverage historical data and statistical data to prepare for the future. Cloud computing, right? As much of our work product moves online into this virtual cloud, how should we protect and safeguard that data? DocuSign. I see a student of mine, former student of mine, Carrie Hughes, who was involved early on with DocuSign. That's also a game changer, right? The fact that we're able to e-sign. I write many of my recommendation letters using DocuSign now. And I will say, we don't have a logo yet, so I haven't included it here on this slide, but I also shared with my students a venture that I'm working on. So I'm working with two colleagues at our UCI Bren School of Information Sciences and a researcher from Microsoft. And we've come together to develop a platform which we will launch in June at one of the largest security conferences. It's an online platform that we've designed to ensure that a contract meets the basic minimum legal requirements of mutual assent and signature attribution. And so I'm so excited about it. And I tell my students, this is why I want you to be open and imaginative and really innovative, because I found that, even as a lawyer with very little training in computer sciences, I was able to make contributions and really learn from as well as teach my collaborators about, designing tools that can really make a difference. And, we've disclosed our invention. We're going to file a provisional patent and then hopefully a patent. And then, the next step is commercialization. And I've, brought my students, a student of mine along the way, she's a third author on the paper. She's going to be an important member of the founding team. And I just think there's so many exciting opportunities, right? And lawyers can really drive as well as, set the bounds of what's possible in these really exciting collaborations. Some other topics that were discussed in the class, we talked about boundaries of personhood. What can the corporate personhood debate teach us about, that boundary line, that slippery boundary line, as you know, between artificial and natural persons. We also talked about who's going to step up to regulate in this space. I've written about this topic, and I'm in a paper called Corporate Long Arms, which essentially, acknowledges our starting point, which in corporate law is that Delaware is the dominant supplier of corporate law. 2/3 of Fortune 500 companies are incorporated in Delaware. It's a state that has more business entities than it does natural persons, right? And so that's been sort of accepted and as the starting point of corporate law. But you can see as new technologies, as new risks, and as new opportunities arise, we see a shift in this playing field where more commercially significant states like New York and California are introducing, their BIT license, their privacy legislation to say, even if you are a company that might be incorporated in Delaware, to the extent that you do business with our residents, these rules will apply to you, right? And so it's important to think about that shift. And then, in addition to the question of who, we have to think about what, right? We talked about external regulations, especially antitrust. If you think about, antitrust and how its sort of singular view as price, as anti-competitive price, as sort of the evil of monopolistic behavior, that framework doesn't really translate well into the digital or data-driven economy, where most things actually are offered for free, right? You're not paying any money for it, right? To be a member of Facebook or to run a search on Google. But you are paying, right, with your information, with your search stream, with your click stream, with your attention, and with your personal information. And so, we need to rethink what we mean when we say, anti-competitive. What does that mean in this new space? And so to the extent that those existing levers are incomplete, I really believe, and this is my most recent project, I'm thinking about, what are corporations themselves doing? Not because that they're being told to do this, not because they're being forced to do this, but because it aligns with their corporate mission. What can companies, leaders, employees, culture, what can those forces do to really flip the switch, right? And so we covered a case study of Luna DNA, which is the first health and DNA platform which offers ownership shares to members for contributing their personal health data. So this is a complete game changer. If you think about incumbents in that space, like 23andMe or Ancestry, where people actually have to pay, right, for the kit, and then they swab, and then they send it back, and then what they get is a report, and what the company gets is their data, right? And their consent to share and sell that data, right? That's been the usual norm in that space. But Luna DNA has flipped that around and said, if you give us data, we give you shares. And if we use your data, by the way, with your permission, and that gets used for medical or pharmaceutical research, and we receive a fee for that, you receive a dividend because you are an owner of a share that represents a pro rata share of those returns. And so, there's a lot of innovations happening in the corporate governance space as well. So we talked about that. My real puzzle is, though, why aren't there more of these, and why aren't they more successful, right? And so if you have ideas about that, please ping me, because this is the topic that I'm living in and breathing in at this moment. We also had a number of guest lecturers. Fred Tung from Boston University, we were able to squeeze him in right before travel restrictions landed. And so he came to talk about banks and innovation. Emilio Cazares from Shepard Mullen and Veronica Reynolds from the Blockchain Acceleration Foundation came and spoke to us about smart contracts and blockchain. Karen Shin, I don't know if she's on the call, but she's an alum of UCI Law. And she also worked very closely with me as a research fellow at the Korea Law Center. She spoke about the California Consumer Privacy Act, so well received by our students because it's a hot topic and an important one. One of my collaborators, Wasim Al-Sindi from the MIT Media Lab, came and talked about his project, Token Space, which is this really innovative idea that creates leveraging existing data. He creates a formula, a calculus that can be used to determine the extent to which a crypto asset is a security versus a token versus a commodity. And so, yeah, we were able to share a lot of interesting ideas, and I really wanted to use this opportunity as I wrap up my remarks as to invite you, in the spirit of our digital economy, which is based on peer production and sharing. Every one of you who are here today, if you have ideas of how new and emerging technologies are disrupting or changing or improving the practice of law and business in your respective fields, please send me an email, and I'd be happy to continue our conversations offline. Thank you so much for giving me your time and letting me share with you a little piece of what we're doing here at UCI Law to merge new developments in technology together with our innovative curriculum. Thank you.
Thank you.
If you have time and questions, I'll be here for the next few minutes, so please jump in.
Yeah, I have a question, and
Sure.
I believe in connection with the topic you mentioned a minute ago with getting ownership interest in return for data, and why that's not happening more. Are you referring to why that's not happening more? You're wondering why so many people freely give away their data?
Exactly. Yeah, this is the privacy paradox, right?
Yes.
People say they care, but they do not act in ways that suggest they care. That's exactly it.
Do you think that the terms of agreement are actually uh, adhesion contracts?
I think that's exactly it, right? It may be that people do care and they would be upset if they knew, right, really the extent to which surveillance is pervasive and very intrusive, right? But it's because those terms are either unknown or, as you said, there's an adhesive nature. There is no other reasonable alternative. Yeah, I think that's absolutely something that's driving sort of this so-called bargain. Um, but what I'm curious about is, Luna DNA, MeWe, Brave, DuckDuckGo. These are, companies that have emerged as sort of competitors and alternatives, and they haven't really gotten the market share that you might imagine because users
Isn't
haven't
that
switched.
isn't that because they're typically acquired by these other companies who want to make sure that that model doesn't survive?
Yes, I think that's one trend, right? Yeah, this is
Yeah.
true, right?
Mhm.
I think that's exactly it. There's
The NHS
skepticism.
are not effective in that space,
Hmm.
apparently.
Yes, right. That's exactly right. And so, there may be, right, this idea that, we're being sold this privacy-oriented suite of um, products at this moment. But who's to say, right, that model will endure, right?
Well, yeah, except that the basic difference, I think, there are two models emerging in the world.
Mm-hmm.
There's the model, let's say, in some countries where the state owns all the data. And
Mm-hmm.
then there's the model in other countries where, in essence, private individuals, very wealthy, super wealthy private individuals control all the data.
Mm-hmm.
Uh, and so the greater share of the population is in the former countries.
Mm-hmm.
So the more data anyone has, the more power
Mm-hmm.
they have. And so ultimately, that model will prevail. Isn't it the paradox, of the state owned enterprises, so to speak, versus a appropriately regulated, private economy?
Mm-hmm. Yes, and I think, I would add to that a third strain, right? It's not yet visible, but I hope it will one day become more prominent. It's the owner-owned model, right? You talked
Mhm.
about sort of the state-owned and the institution-owned, right? But thinking about, owner-owned, user-owned, and you mentioned two concepts. One was ownership, and the other was control. We see these as two separate things in governance, right? And the Burley means problem that has plagued corporate lawyers for a century, over a century now, is that separation between owners and control. And we always talked about that dynamic in the context of capital, right? People invest money, but they don't get to control the day-to-day of how their investment is used. But they sit back and they are given sort of returns in the form of dividends or capital gain, right? And that sort of that was a delicate balance that was able to be reached through corporate governance and corporate law protections like fiduciary duties, voting rights, and things of that nature. I think we just need to bring that paradigm over to the data space, where we also have to think about who owns, who not only owns, but who also controls the data. And I think what I find is very innovative with what Luna DNA and some of its other peers are doing is that it is really trying to restore trust by bringing ownership and control over data to those who provide that data. And they do that using technology, using inspired leadership. And I think the only, one of the main barriers though is what you said, right? That who knows, if this company will do what it says in the long term, right? Facebook too started out as a pro-privacy, very strictly verified accounts only, right, platform. And so, that David and Goliath circle, as when you get bigger, and then a new challenger arises, and some of the promises made are not kept because costly trade-offs need to be made. That's a story we've seen recur. So I think you're absolutely right that that is that one barrier, right? The skepticism, and then the lack of knowledge, and then thirdly, just cognitive biases that we have. We tend to undervalue things, right?
And also, I don't want to.
No, Peter, I think you and I need to continue this conversation
Yeah.
offline. So please be in touch. I don't think we've met before. Where are you based?
I'm right around the corner from you in Newport Coast.
I see. And were you? Are you a lawyer?
I am a lawyer, but I have not practiced for about 25 years.
Ah, yeah. I too am a lawyer. I haven't practiced for a while either. So.
I do consulting work to large law firms.
Mm-hmm. So you're very knowledgeable, right? I think you're someone we'd love to hear from, right? As students, when I surveyed them at the end, that was the exit survey. I asked them, I'm going to offer this class again. I received actually a modest award from our Office of the Vice Chancellor of Research to develop this class and reading materials for this class. And so, I asked them, what do you want to learn more? Because this is going to be offered again and again and again, and it's only going to get better. And one thing they really want more information about is how the legal profession is changing. How are billable hours changing, or are they even there, right? Alternative fee arrangements. How should we think about AI and new, just e-discovery and litigation analytics tools? Should we learn them in law school, right? And I think what's been remarkable is that through this seminar, we went through a pandemic. And so we had many discussions about our ability. People say the legal profession is slow to change, right? But I think, when we are forced to change, we can change more efficiently and more risk adjusted than any other profession, right? And, we execute. So I think, seeing how COVID-19 really supercharged the transformation and resiliency of the legal profession, I think was really inspiring to our students. And so we brought together headlines of the various transitions that were being made, the Supreme Court hearing for the first time, arguments virtually, all the memes that were being made, the shirtless lawyer who was asked by the judge to put his shirt back on, the barking dog who had to be muted and, sort of wiped out of this frame. And, there's so much that's going on that, really we're living this moment and so much is happening. So, I think when things are back to normal, whatever that means and whenever that may be, we should have you on our campus to talk about some of the work you've been doing with your clients.
Happy to talk about that.
Great, wonderful. I've really kept you all for too long. I think that we were supposed to end this at 9:30, but if there are others who want to connect, now would be the time to jump in, or please email me. I'm at skin. I'll just type it into the chat here, my email address. So please do reach out with any ideas, suggestions that you have. All right, thank you again to Marianne and Rebecca, and I see Dennis Sloan, who leads the development team, has joined, and he's there waving as well. Thanks to you for bringing us all together. Thank you to each and every one of you who dialed in on this Friday morning. Happy May, happy Family Month, happy Community Month. Please be well and safe, and be in touch.
Thank you very much.
Thank you.
Thanks, Summer.
Thank you, Summer.
You're very welcome. Thank you both. Bye-bye.
Bye-bye.